live again, or I'm going to write one next year regardless, and hopefully I'll get up there to visit you guys. I know Damian's going to be on your schedule, teaching schedule, a bunch virtually, and maybe at some point in person. And like I say, I hope we can participate in this event in some capacity next year. But this is what we've been calling potpourri, and it essentially is just a bunch of topics. I won't, I'll show you our extensive high-end topic list. I don't have a screen to share, but there's a bunch of things to talk about. And this is meant to be a dialogue, not a monologue, and not just a dialogue between Damian and myself, but hopefully you guys have some input and questions. I don't know if you're supposed to do that in the Q&A box or the chat box, but wherever you do it, we'll pick it up, and I'm happy to answer any questions about any topics. But we've got kind of a list that Damian and I have gone over, and we're going to kind of bounce some things back and forth. And if you guys have questions about any of these topics, feel free to chime in during it. And if it's other topics, then jump in when you will. And this will be hopefully a good back and forth session. So topic number one, and I don't know how we get out of it. I don't know how we ever get out of it, but Damian and I both agree, like, we don't want to belabor this, but COVID, if you guys haven't heard of it, is still a topic of the day, believe it or not.
There might be people that don't have any idea what we're talking about.
There could be. It could be. Something tells me that's not the case, but all kidding aside, there are remaining issues. And I will say this, that we have hit in many respects, or had hit, I think things are kind of evolving pretty rapidly right now with escalations and some additional concerns and some additional limitations in certain communities. And so we'll see where things go. But over the last several months, things have been relatively static in terms of, curveballs within the real estate industry specifically. Once we got out of those early days of, various municipal and county orders differing from the state, and limitations on showings, limitations on open houses, and all the things that were really, really difficult, we kind of hit a pretty good pattern. And I think it's a real credit to you guys as an industry and our industry partners as well, how well you all moved essentially from a dead stop from, call it mid-March through, I don't know, late April, early May, literally a complete dead stop, into one of the highest velocity, highest volume real estate markets that I think any of you guys have ever seen. And that is not just along the Front Range. It's the mountain resort community. Certainly you guys are getting a ton of it. It's the Western Slope. I know Grand Junction, they're seeing market velocity that they've never seen before. It's Pueblo all the way to Fort Collins and every corner. And so to move really as an industry from a dead stop to incredible volume and doing business in completely unique and different ways has been pretty amazing to watch for our industry as a whole, and for our industry partners, our title friends, our lender friends, inspectors, appraisers, everybody just having to do things completely differently, and not just do it in a status quo market, but do it in a market that is exploding here throughout the entire state of Colorado. And so that's all good stuff. And hopefully we can keep that status quo going as much as possible going forward, and that we don't see some of the winter implications and other flu derivatives that might be making an impact on our ability to do business. And so Damian's going to talk a little bit about why don't you want to pop your dial thing up on the screen there?
Yeah, real quick. So a new order did come out, and I just want to let's see if I can figure out where this is. I just want to share this with you guys real quick. So this just came out. It's fresh off the presses. It came out yesterday, and it really didn't change anything. As Scott talked about, a lot of our industry has been pretty static since they straightened out stay at home and they ended up in safer at home. But what they did do is they combined all of the different orders that we've seen. So we now have one order called the COVID-19 dial that deals with protect our neighbors, safer at home levels 1, 2, and 3, and also stay at home. So all 5 of those levels are now incorporated into this order. And I'll tell you, I've gone through it, not in a lot of detail. And I know, Scott, you haven't spent a whole lot of time on it either, just because it just came out yesterday. But from what I can tell, there's really no difference. The biggest difference I see is for offices, you're at 50% occupancy, and you have to drop to 25% occupancy if you end up in the orange level. And then obviously stay at home, you can't occupy at all. As far as I can tell with field services and the safer at home and the protect our neighbors, it's pretty much every status quo, everything we've been doing before. But I wanted to give you, did the dial come up, Scott? Because I can't tell what I'm sharing or not sharing.
You're on it now.
Okay. So I wanted to share with you what the state has put together as far as a dial. This is a living document that's on the state website that kind of tells cases, what level every single one of these counties is at and what's going on. If you were looking at this last week, you saw Summit County was blue. It's now moved from safer level 1 to safer level 2. It's now in the yellow. Denver moved from safer level 2 to safer level 3. Same did Adams, Logan. There's notes on here about enforcing stricter public health orders if the county is enforcing stricter orders. So for Summit County, they're enforcing stricter orders, and they amended their order on October 29th that has a little bit of increases that you need to be aware of if you're up in Summit County. Namely that offices are at 25% efficiency and you have to wear masks and pretty much face coverings is outdoors whenever at least 6 feet of separation cannot be maintained amongst individuals. So that's a higher level than what the state has. So if you're not familiar with it, you might look at it, but as Scott said, for the most part in the real estate industry, we've been fortunate in the fact that even within the changes in the safer at home order or the protect our neighbors orders, there hasn't been much variation for what real estate brokers need to do in order to perform their jobs. So I'll stop sharing, Scott, and send it back to you.
Yeah, and Damian, if you would, could you copy those links, particularly the link to the website, and just put it in the chat box?
Sure.
I think if you right click, and normally I'm there to assist Damian with his administrative tasks like this, but hopefully he can.
You wanted it? I'll put it in the chat. Okay.
Yeah, put it in the chat box just so people can click on it and see those things, and maybe even the other PDF documents. But in any event, I will. So do be mindful of that, because I think what we're seeing is an awful lot of chatter about different areas doing different things, and I think the biggest difference now is that we do have one defined resource for that, whereas back in March and April and May, it was very hard to get your arms around what counties were doing individually. And so that's a great resource that Damian's linked up there, and it is a living document. So do keep that handy as you're considering your businesses. Just two other little areas in COVID, and then we'll move along to some other topics unless you guys have specific questions. The one area that I'm still getting a ton of hotline calls on is related to tenant occupied properties. And that's in a situation where it's either it's an investment deal where it's going to be sold with a tenant in place, which has probably overall less concerns than a transaction that's going to be sold that has a tenant in place currently, but it's meant to be sold to a buyer who will be not accepting the tenant or not accepting an assignment of the lease with the tenant in place. And that's got some real issues. And so I'd say almost consistently, I'd say 2 to 3 times a shift on a hotline shift, I will be getting calls from around the state asking about kind of the eviction implications, as well as how do we navigate this situation. The cautionary statement I would make for you guys as listing brokers, if you have a situation like that where there's a tenant in place on a listing, or you're meeting with a seller who is thinking about listing the property with you, and they have a tenant, if it's an investment deal, then you might have some challenges with showings and access to the property, because the tenant could always say, you're not coming in, I don't care what you say. And in that case, please don't go in. Please don't force your hand. Please don't push that. But that's the concern there. But the real concern that I see and the real implications of problems that I see is a situation where the intention is to sell the property without the tenant in place, but they're currently in possession. And I hear all the time brokers go, well, I've told the seller, they need to worry about this. And the seller's saying, oh, this is the best tenant. They've always paid their rent on time. They're very cooperative. They've assured me that they're going to move out a week before closing. Well, things change, and tenants realize they can't find replacement properties. Maybe they lose their job. Maybe they're not going to be eligible for another property application. Who knows what happens? Maybe the tenant that they're going to replace isn't moving out, and so now they don't have a place to move to. When that happens, the implications for a seller are significant, right? Because you are now in that eviction range. And I don't care if somebody's in breach of the lease, if they are holding up their hands and saying, I'm unable to move as a result of something to do with COVID generally, then, I mean, and Damian, you can, I think, reiterate this, but we've both spoken with eviction attorneys that would tell you, even as of right now, the very best you're going to do as a landlord trying to get a tenant out of possession of the property is probably sometime next spring. And so imagine a scenario by which a seller has agreed to deliver possession, here the middle of November on a sale. The buyer says, well, I'm going to go ahead and close, I suppose, but now that penalty for per day for delayed possession is what is now kicking into place. And those are often set very significant. They're very high. It can be, I've seen them as high as $500, $700 a day in some cases. Imagine your seller client in that situation that can't deliver possession and is now trying to remove a tenant so they can deliver possession sometime in spring. That could get incredibly painful and expensive. Damian, you want to chime in on any of that?
Yeah, I mean, it is a tough issue. I mean, I've seen it even when it's not even the tenant, when you have a seller that all of a sudden decides to overstay their welcome with a post-closing occupancy agreement, and that might be subject to the same rules and regulations under COVID. All of a sudden they can't move into their new build, and now they're claiming that it's because of COVID as to why they can't move. And I mean, it feels like there should be some remedies for a buyer in at least the one situation where it's the seller that's not leaving. But the courts are backed up. They're all doing virtual hearings. They're very sensitive to people that are claiming COVID as a hardship. You just really got to be cautious and warn your buyers about this risk that they're undertaking when they're buying property where somebody is going to, when they might end up staying. I mean, whether it's the seller, whether it's a tenant, at least help them understand that there is a risk involved in buying real estate these days. And hopefully it works out, but if it doesn't, there may be some pain.
Yeah, absolutely. And you brought up a good point with the PCOs. I've been getting those calls as well. And there's actually one in the chat box, but can we get a post-closing occupancy agreement? It's a commission approved form. So you'd be able to get it off of your electronic form set through, I think you guys use CTM e-contracts. It would certainly be there, or the division's website, but that's a commission approved form. But bringing up the post-closing occupancy agreement, that's a great point. I get a lot of calls. Does that apply? And I think the answer is absolutely yes. I mean, that is a possessory interest in property that seller/tenant has, and the buyer/landlord is going to have to go through the eviction process if they actually want to have to remove them. And so all of those things are important to be thinking about, just because as it is now, I think we're going to be through we're in a 30-day eviction moratorium at the state level. We've also got a federal eviction moratorium through the CDC, although that's being pretty aggressively challenged, I think, legally, but that goes through the end of the year. But what I think we've seen from Governor Polis is a series of reissuing 30-day executive orders, because that's a statutory limitation that they have. So I would be sort of surprised, barring some significant changes for the better, that Polis doesn't just extend out the 30-day eviction moratorium when it expires, which I think will be in about 2.5 weeks or so from now.
Yeah, and if nothing else, probably until the end of the CDC order, or whenever if it gets challenged as unconstitutional, then potentially, then they might take it down. But I know there's a lot of eviction attorneys that have at least talked about whether or not they're going to have to get dirty with the, suing the state over whether or not they have the rights to pass these things. But, any kind of lawsuit like that is going to take forever. It's not like it's going to be just decided overnight and all of a sudden, oh, great, now we have rights to get rid of people that are overstaying their welcome.
Yeah. So that's a big issue, and be mindful of that. Anytime but please be respectful of it as well. That's one way we can get ourselves as an industry into trouble real quickly, is if we're trying to push tenants out to do showings or to access property, or telling them they have to leave or they have to vacate. You gotta be very careful and sensitive with any of that. That's one way we can get into trouble. The last piece of COVID that I'll mention, unless Damian's got anything else, is the form usage. So 2 forms, and Damian was instrumental in putting these together, the buyer advisory and seller advisories. Those are great documents. They're easy to use. Please continue to use those until until we're done talking about COVID, I don't know when that'll be, but I think if you're representing a seller to be providing them with a seller advisor, if you're representing a buyer to be providing them with the COVID advisory to the buyer is maybe not 100% exculpatory. It's not going to necessarily completely save your bacon, but it will be a nice thing to have in your file if somebody ever challenges your level of professional care or standard of care as a broker with regard to this virus. Damian?
Well, obviously I like the forums because it does give you guys, if nothing else, it's a talking point to, I know a lot of people have probably heard COVID exhaustively, but to me, it's more putting it in context of real estate and helping your clients understand the risks that they're assuming when they're either buying property or selling property. So do keep using those. I will warn you, I know that there's attorneys that have drafted other forms. I think those have their own present dangers for people. While it sounds good to get an indemnity from a buyer that's entering a property, the concern I have is you're now requiring the buyer agent to tell the buyer that they have to have an attorney review this legal document before they can ever sign it and enter the property. And at some point that could be detrimental to sellers. If you're not using it at open houses, then you're using it inconsistently. Just be wary about using forms that start to get into the legal realm of indemnity, release, waive, anything along those lines. If you're going to use them, that's fine, but use them under the advice of your attorney and understand their limitations, and also understand the limitations that you're imposing on the other side, the other buyers that might be looking at your properties.
Yeah, 100% agree. The last form thing that I'll touch on related to COVID is the the COVID addendum that was promulgated by the Colorado Bar Association at the very, very beginning of this pandemic. I'm still getting calls from brokers that are like, well, the other side's trying to use the COVID addendum, or should I be using the COVID addendum? I would say at this point not, although again, as things spike, I mean, so that form is really meant to address at the early stages where there was uncertainty, like, hey, will title be able to close the transaction? Will the appraiser be able to get on the property? Will a lender be able to show up at the office to get an underwriting deal done? As I said at the outset, our industry has done a phenomenal job of being responsive and keeping things moving forward despite all of the challenges. And so I think some of the practical use of that document has completely gone away. And so I would not be fighting over the addendum at this point. I wouldn't be using it at this point. But if things change and we're back to some stay at home or other level of uncertainty, then it might be a document that will be sort of educating you guys on trying to incorporate into your businesses again. Again, fingers crossed, hopefully not, but remains to be seen. Anything on that, Damian?
Yeah, just to reiterate, I agree. I'm hoping that we never have to use the form again. I think it was actually, I think it was great. Carr asked the Bar Association for a form because the Real Estate Commission could not act quick enough. And so getting you guys that form was something that was very, very important back in March, April, even May. Hopefully we never use it again, but if we do see increases in spikes and we go from the safer at home to stay at home, that might cause possibilities for some of the providers, whether it's title companies or the clerk and recorder's office or lenders or something else. And if we start to get into a world where there's some impossibilities because we're just shutting everything down, that form could become important again. And just know that you have it available if you need it to help push some dates and help you guys keep deals together.
Yeah. Okay. No more COVID. Well, it'll have to sneak its way in some way at some point again. But in terms of our topics, we're going to move on to some other things that I think will all, be interesting to talk about that are not COVID related. So, and again, if you guys have questions, throw them in the Q&A or chat or wherever. We'll kind of watching both of those. Actually, there is a question. Is there any consideration for the size of the office? For example, SAR has 4 employees in a 5,000 square foot building. Damian, you've been advising your brokerage offices a lot on this, so I'll let you take this one.
Well, the thing is there's these for indoor events, there's this calculator, we have these open houses that you're supposed to have this calculator that you calculate, okay, the square footage is this big and how many people can you have in this and 6 foot distance and all this. I mean, for open houses, my advice has been just take them through one group, one socially distanced group at a time. So if it's somebody all from the same household, they can all go through at the same time because they've been socially distancing together. For the offices, it's I don't know what they're basing the occupancy on. I don't know if that's a fire marshal or if it's how many desks you have or whatever. But my guess is it's more based on the occupancy that a fire marshal would say for the space, Scott. I mean, that's kind of been my interpretation of it. I don't know, maybe you've seen something different, but you know, if your occupancy you see in a training room is typically, you know, 40 people, then, you know, 25% would be 10. So that's what I've been telling people, because it isn't exactly crystal clear as to what they're basing that number on. From what I can tell, the offices do not have to use the socially distancing calculator like the open houses do. So I'm assuming that the occupancy limits are based on fire marshal code.
Yeah, I think all of the business operation stuff has been based on a percentage of total occupancy, which, as Damian alludes to, I think is the only definition or understanding of that I've ever had would be fire code occupancy limits. So, all right, we're moving on. The next thing we're going to talk about is things are getting chippy out there, and as Damian will tell you, chippy is a legal term of art. It's a very sophisticated word. But it does represent the sort of feistiness and litigiousness and I don't know, angst and everything that I think we're seeing. And I'm going to say that things are getting chippy for a couple of reasons that I'm seeing, and then I'll let Damian talk about one of the things that he's familiar with. Number one, legal hotline call volume. So the legal hotline that I get to administer, and we've got, you know, if you call and you don't get me, then you're fortunate because you'll get some other attorney and not have to talk to me. But it's available 9 to 12 and 1 to 4 Monday through Fridays. And in a typical, over the years, and many of you have probably heard me say this, in an average 3-hour hotline shift, we'll get about 15 calls, so 30 calls a day. I would say that our average hotline shift is up probably 20 to 22 calls, and over the course of a day, 40, I've had as recently as many as 47 calls in a day. So a very significant increase in hotline call volume tells me that things are getting chippy. The other thing that tells me things are getting chippy is we administer professional standards, CAR does, and one of the things that sort of falls underneath what I do at CAR is our professional standards administration. And our pro standards administration, our grievance committee meets once a month, and in an average grievance committee meeting, and so grievance committee hears every arbitration request and ethics complaint, and they don't hear they're not the hearing panel, but anytime somebody submits a complaint, they are the ones to determine, yes, it's an arbitral matter, yes, we're going to refer it to a hearing panel, or yes, there's a potential ethics violation, yes, we're going to refer it to a hearing panel. So it's every complaint that comes in. On average, over the last 6 years or so since I've been at CAR, in a grievance committee meeting, we will consider probably 4, maybe 5 complaints that have come in during the course of the preceding month. Over the last several months, we have been up in the 10 to 12 per month range, so significantly higher in that regard. And then the last thing that I think is good evidence that things are getting chippy, I'll let Damian touch on real quickly here.
Well, one of the jobs I do for my clients is that we deal with a lot of the E&O insurance claims, and we deal with a broker that actually works across the country dealing with E&O insurance with different brokerage firms. And he's told me that in the last month or two, he's seen in the last 2 months the number of claims that normally you would see in a full year. And that's, you know, buyers suing brokers, sellers suing brokers, buyers suing sellers and dragging in brokers, just those kind of things, as well as real estate commission complaints. So we're seeing a lot of volume of complaints coming against brokers, and you know, and Scott, I'm sure is going to talk about why that is, but it's pervasive across every measure of dispute resolution that's out there.
Yeah, I mean, so that is, if you think about E&O, that represents the sort of civil liability world. If you think about pro standards, represents kind of the association dispute world. And then if you think about the hotline, it's the very front end of any of these disputes. It's kind of the initial reaction of, hey, this occurred, is something going on here? So what does that represent? I mean, it represents, I think we are in a very tense time. There's a lot of people that as active as the real estate market is, and as busy as I think individual realtors are, I think there's a greater awareness of grievances generally, a greater willingness to point fingers and complain and actually take action on those grievances. And I think it's a reflection of frayed nerves, COVID quarantine problems, hot political dynamics, a lot of social, racial sort of injustice and agitation going on, and it's really being reflected in the business. So I'll talk real quickly about in terms of things getting chippy on the hotline piece. I'm seeing a ton of earnest money disputes, a lot of phone calls related to earnest money disputes, situations where oftentimes a seller is not releasing earnest money in bad faith. In other words, they just say, well, screw you, I took this contract. And I think this kind of goes back to the fact that we've had a lot of high velocity market. So imagine a seller who gets multiple offers and then picks a buyer based on some really aggressive offer. And maybe this is something I'm getting all the time lately, is these buyers are writing in these stupid, they'll only object to health and safety issues or whatever, which I know Damian's got some thoughts on there, and I'll let him chime in. But what ends up happening then is that the buyer ends up objecting to something that is maybe not subjectively a health and safety issue from the seller's perspective. And so the seller says, well, I'm going to fight this out and I'm not going to release your earnest money. I'm getting a ton of that. Damian, you want to talk about your health and safety clause feelings?
I love health and safety. Who decides this? Who decides what health and safety is? I mean, does that mean if it's a broken window, it's a safety issue? I mean, the window could break and it could hurt somebody. I mean, is that a safety issue? Is it, to me, I get that buyers are, and I get where it comes from. I mean, let's face it, you got buyers that are trying to make their offer stand out. They're trying to get a seller to accept their offer over somebody else. And it's like, okay, how can we do this? Okay, what we're going to do is we're going to make it that our inspection items are going to be very, very limited. We're not going to ask for everything under the sun. We're only going to ask for health and safety. Well, the problem is I don't know who gets to decide that. And I think who gets to decide is probably, probably the judge once there's a dispute over it. You can see where the seller says this isn't health and safety, and you said you wouldn't ask for it, so you're acting in bad faith. And you have a buyer that says, oh, of course it's health and safety because I can come up with a reason that it needed to be health and safety. And it just creates conflict. If you're representing a seller, just give the buyer the right to inspect. You want to protect your seller, move that date up. I mean, that's the best way to protect anything, is to make your deadlines tighter. Don't try and take away rights or leave a contract that's open to interpretation. I've said this before that, ambiguity in a contract favors the lawyers. So, don't make it ambiguous. Make it pretty clear cut as to what's happening. Clarity in a contract favors the broker because there's less room for people to fight. Brokers love playing in the gray. That's our job. So, give us these terms that can be ambiguous, and you just hired lawyers and paid them. So that's my 2 cents. I know I ranted, but
yeah, no, I feel the same way. And just if you're a listing broker and you want to protect your seller, shorten that deadline. Make it. Most buyers can go get an inspection in 3, 4, 5 days, and at least then you're not hung out over 10 or 15 days, and you feel like you're protecting your sellers with some health and safety caveat, because it just doesn't really mesh with the pure subjectivity of an inspection objection to begin with. And then ultimately, like I say, who decides? I literally had a call last week on this, and this was the health and safety objection, was that the garage was not large enough to fit the buyer's truck. Okay, so they couldn't get their truck in the garage. And as a result, they weren't going to be able to park in the garage. As a result, there was a greater likelihood or propensity that they might slip on ice in getting from their vehicle into the home. And that was the health and safety objection.
Sounds good. Well, and the other thing I want to point out, because for some reason, everybody thinks that a seller has to address health and safety. Guys, they don't have to address any of this stuff. So just give the buyer the right to object, make the resolution deadline short, and move on. But yeah, I mean, anything can be turned into health and safety. It's just, yeah.
Yeah, and so then the other thing I'll touch on real quick with pro standards stuff, and so that's a hotline call. The earnest money is I'm getting a ton of hotline stuff. On the pro standard side, we're seeing some ethics complaints about realtors presenting a true and accurate picture. Is a very increasingly, I would say, common complaint. And what is often happening is a broker, as an example, puts in the MLS that there is, well, the easy one is like central AC, right? They put in the MLS, house has central AC. And I can promise that I will get calls and complaints the first hot streak that we get every single year. The buyer who bought the house closed a few months ago in the winter. They never thought about the AC. They never paid any attention. They go to turn on the AC, and guess what? They don't have central AC. It doesn't exist, and they didn't pick it up through inspections or anything else. Well, that's a tough thing for a buyer to really have any recovery on, unless there's some additional evidence that, this was intentionally misrepresented, or the seller misrepresented it, or there's something in the contract specifically about providing central AC. So it ends up becoming a real, what ends up happening is that the buyer ends up trying to poke the listing broker in the eye by saying, you didn't present a true and accurate picture in your advertising and marketing. And frankly, they've got something there to some degree. At least I've seen results in ethics hearings where the realtor has been found in violation of the article because of that. And so my point being here is that despite the high velocity, despite the high volume market, despite the seller's frenzy to get the property listed and up on the marketplace, make sure that you guys are being super careful with your MLS entries, with your marketing materials in general. You don't have a duty to investigate. You specifically statutory no duty to investigate, but there are things that you maybe want to be challenging a little bit, like central air conditioning in Summit County may not be all that prevalent. And so if you're going to be throwing that in based on some representation the seller's giving you, you might want to, push back on them a little bit and make sure that they're actually, showing you how it all turns on or something like that, right? And so that's the ethics side is kind of post-closing frustrated buyers that are looking to poke a realtor in the eye because of something related to the advertising and marketing. So Damian, any thoughts on any of that?
Yeah, I will say that this a lot of times comes up right before closing, that they find out that there's no AC, and they think, oh, well, the buyer thinks that, oh, well, the listing broker has an obligation to buy me an AC unit because they knew about it. I will tell you, after closing is a little more complicated, because the question is, did the buyer know or not know, or should they have known? If they know before closing, buyer has a right to walk away. If they close knowing that there's no AC unit in the property, they are probably foreclosed from bringing any of those claims against the broker or the seller. So, make sure buyers understand that there is no second bite at the apple after closing. That's merger doctrine, and you're done after that. And if you know it ahead of time, then you're accepting the condition of the property.
And that's speaking civilly. In terms of filing an ethics complaint, there would be eligibility to do that. And, there might be analogous sort of division of real estate or license law concerns, at least potentially. So just be cautious, as you're preparing your marketing materials, as you're entering stuff into the MLS. Again, just because things are getting chippy. You want to touch on any E&O stuff, or any any volume or areas of focus that might be important?
A lot of the E&O stuff is the same thing that you see in the real estate commission complaints, or even in your ethics and professional standards stuff. It's misrepresentations about the property. Or another one I see a lot of is not, when you're talking earnest money disputes, of, buyers not telling their full financial picture. And that comes back on brokers too. If the broker knows about the buyer's ability to purchase the property, or knows something material about the buyer's ability to purchase the property, and doesn't disclose that to the listing broker or seller, then they're opening themselves up to a real estate commission complaint, as well as any kind of ethics complaint, because there is a duty that if you know something about the buyer's finances that's material, that you have to disclose it to the seller and the listing broker. That's the buyer's side of adverse material facts, essentially. So, those are the things that I kind of see, similar to what Scott's seen. Lots of earnest money disputes right now. And I don't know why, but for some reason, sellers all of a sudden have decided that everything is bad faith, and that they feel some kind of entitlement that they should get money back. Normally, it's just not worth it. I mean, at the end of the day, the seller's got to go to mediation, and then they got to go to court, or maybe hire a lawyer. And it's a lot of brain damage and time that doesn't make sense for the amount of money that we're usually talking about with earnest money.
Yeah, totally agree. And Damian brings up a good point that we talk all the time in terms of seller's property disclosure, in terms of adverse material fact and the seller's obligation to disclose those. but there is the same expectation of disclosure on the buy side and representing a buyer. And if there are adverse material facts related to what your buyer's ability to perform is, or the conditions of performance, or any of those things, those are mandatory disclosures as well, that we just don't, but by virtue of the fact that they don't come up as much, we don't end up talking about. But it is important to remember that it's the reciprocal of the expectation that a broker is going to be disclosing property conditions that are adverse material facts of which the broker is aware. So, okay, so that's the chippy topic, and I do, hopefully things calm down in our world, and we can become a little bit less chippy. But it's all these Californians moving here to this state is what's going on. The most litigious state in the country, and Damian's a native of Colorado, so he can be judgmental. I'm actually.
Hey, Scott, where do you come from again? I forget.
I was going to say I actually came here from California. Now, it was 99, I guess. So it's been 20 some years, and I've never sued anybody or been sued, but I might be more part of the problem than the solution. But anyhow.
I see we got a Q&A. Do you want to go through that? It looks like it has to do with COVID, because I know how much we like talking about that.
Go for it. For open houses, part of the new public health order for Summit County says that no more than 2 households in the same indoor space. Does that mean only the broker and one other person or group from the same household can be in the same open house at once? I would say that does. I'm not specifically familiar with the Summit County piece of that, but if I'm understanding how you're defining that, I think it would be applicable. Would you not agree?
Well, first of all, I think that's the better approach. That's what I would do anyways. But there's a distinction. Scott and I have talked about this before. Like Denver has this order that says that, when it comes to holidays, that you can only have 2 households in gatherings. And I think this is about gatherings. I don't think it's indoor space. The order that I'm looking at from Summit actually talks about indoor events may allow up to 25 people in their usable space using the social distance space calculator, which is what an open house falls under. So that would be the limitation. But frankly, I would not let more than 1 household in there in the broker. It just doesn't make sense. It's not worth it. And who knows what the neighbors who are watching all this are going to complain about or turn you in for. So I would use this as my rule of thumb, regardless of what the order is, but I'm not sure that that's what they were getting at when they said 2 households. I think that was more gatherings for personal residences.
Yeah, I don't, Damian alluded to this earlier when, in terms of best practices for doing open houses, it makes, from my perspective, much more sense. You can control it. If you really look at the open house limitations on the executive order, it's like, you've got to have directional flow in the house. You should not have any more than 2 people in a room at a given time. And so I don't know if you're having a true open house where you've just got people floating all over the place. I don't know how you really control all of that. So I do think, in terms of trying to adhere to best practices, that makes the most sense. So, all right, next topic on this illustrious list here, I'll throw out, is a clear cooperation policy. Another thing that I'm getting a ton of stuff on the hotline about. It's amazing. You guys are very tricky. One thing I've learned about realtors is that you can come up with all kinds of ways to, caveat and cushion and, whatever, all kinds of creative things to get around policies. But the difficulty thing with the clear cooperation policies, there's not really a whole lot of wiggle room, so to speak. And so, the good news about all of that is that it's not like any of your MLS participant competitors or other realtors in your community can really do anything differently than you can. But the biggest issue I'm having with this, and the biggest issue I've had with it since even before NAR passed it almost exactly a year ago now, and it's been implemented, as you guys know, since May 1st, or it had to be no later than May 1st, all realtor-owned MLSs had to implement the policy. And so we've seen several months of it. I thought this year I was going to be spending a lot of time talking about clear cooperation, and go figure, the COVID thing popped up and that became the main focus. But as COVID has gotten flatter or been a little bit less curveballs thrown at us, clear cooperation has been a really big one. So here's the deal. questions about brokerage firms, like this concept of marketing within your brokerage firm. I would look at your at how many at a brokerage office in terms of where you can market without it being quote unquote public marketing. I would look at the division of real estate's a great way to look at it. If there's an employing broker and they have 7 different offices around the state, but 1 employing broker, that is the brokerage office. If it's a different brokerage entity, different employing broker, therefore, then those are 2 offices, or maybe 3, or maybe 7, or whatever it is. And so depending on how your brokerage firm is structured, even having multiple offices, you might be allowed to share it across multiple offices around the state, but that's in the event that it's all one brokerage firm. And so there's a lawsuit going on in California that I won't spend a lot of time talking about specifically, but essentially it's, I think, Brokers Guild, and it's this group that has essentially been the top, X% of performing brokers around the country. And they've had this network essentially where they've been sharing listings, maybe more pocket listings, maybe more, maybe more private overall listings. And that whole business is gone because they're all brokers from different brokerage firms, or that guild has essentially been obliterated in the sense that they haven't been able to share it, because as soon as you send that listing, to your colleague at another brokerage office, or as soon as you put it up on Facebook, or as soon as you put a sign in the yard, or send out marketing flyers, or whatever you're doing, well, you have performed the public marketing function of that. And now you, within 1 business day, have to get that up onto the MLS. And again, the problems that I'm seeing are sellers saying, hey, I don't want my property listed. And in a higher end resort market like you guys are in, maybe there's a greater likelihood of that. They really want you to be kind of a pocket listing, or they don't want to put a sign in the yard, or they don't want to put it on the MLS. There's not a great response for a seller that's asking you to do that. And my issue has been that, it really kind of puts your fiduciary relationship, if you're acting as a seller's agent, it makes it very difficult for you to comply with your client's instruction and at the same time comply with your MLS rules and regulations. So I'm empathetic to all of the creative ways you guys want to get around it, but there's just not a lot of ways to get around it, for better or for worse. Damian, go ahead.
No, we're seeing this everywhere as far as clear cooperation, where and some of the penalties that the different MLSs have, I mean, they're strict. I mean, some of them go so far as to, after so many violations, we're going to take away your MLS access for all of your brokers. So, it's, to me, it's not worth the price. Now, more importantly to me also is that I like the clear cooperation rule, because it goes back to what the intent of the MLS has always been. And the reason that you guys wear an R on your cards or your signs and everything else is that, it's about cooperating within our industry. It's about buyers and sellers being able to go, or buyers being able to go to one broker and know that they have access to your entire MLS. And it's about a value add for consumers, knowing that brokers are valuable in this industry. The clear cooperation rule, while the timing was a little interesting, I think was a fantastic rule for you guys in defending your industry. And I know that it makes it uncomfortable for some offices, or sometimes it's uncomfortable having that conversation with your clients that may not want to put it in the MLS. It still is, to me, a safeguard for your industry and an important thing to adhere to.
Yeah, I've always appreciated Damian's perspective on that, and I agree with him. I think it is a good safeguard, and it does protect kind of what we do and what we create and what we have access to, and there's a lot of value to that. And there's a lot of value to for most sellers, once they understand the benefits of the MLS and the wide exposure, broad exposure of their listing. And generally speaking, I think all of you guys would agree that in most cases that results in a very significant net benefit to your sellers. And so hopefully just having a conversation with them to help them understand that they're not going to go hire anybody else in the marketplace that can do it, can keep their property off the market, unless they want to go hire a non-MLS participant. And if somebody's not participating in the MLS, you got to wonder how active or capable they are of actually, getting deals done. So anyhow, those are that's another been a big topic, and I wanted to mention that. Another topic that Damian and I didn't talk about before this that kind of has come up, and that goes to the chippy stuff, and another I had literally yesterday, I had a call on this related to Procuring Cause. And that's the advent of technology firms. Damian thought I was going to go into right of first refusal in your marketplace, and maybe we'll do that later in Procuring Cause.
Maybe casualty.
Yeah, there you go. But no, the angle on this is some of these technology hybrid brokerage firms, whatever you want to call them. I'm not going to get into naming names, but your buyers, these companies have gotten so good at having a buyer look at their website and they click a little button that says, see the property tomorrow or contact the broker or whatever. And they really sort of lure, and I don't mean that in like there's nothing illegal about it, right? It's just, it's a very efficient or a very strong way of marketing to buyers. But I'm getting all the time now, literally had a call on it yesterday. Broker's working with a buyer is actively doing their own property searches online. And that's, I think, another function of kind of COVID era where people are more at home. They've got more time. They're more in front of their computers. They're taking a more active role, even though that's something we've seen for years. And I think we're only going to see an increase in going forward. But buyer goes to some website, clicks on a link to see the property. They go meet a broker over there. And now we've got a procuring cause issue, right? We've got a buyer who never really intended to go and establish the potential that another agent could maybe make a procuring cause allegation, because meanwhile, they've been mostly happy with the agent or the individual they've been working with. And so this problem is something that I'm seeing a lot more of. And as a cautionary point, I would tell you, first of all, get your damn agreements in writing, right? If you're a buyer's broker, do everything you can to get that exclusive right to buy exercise. That's going to do an awful lot for you, including being able to address your commissions in the contract if you've done it properly. But it's also that's your protection, right? Because that you don't have to worry about procuring cause. If you've got a buyer that's cheating on you or breaching an exclusive right agreement, you've got additional levels of protection, right? But in getting to that point, it's really important that you're having a very robust conversation with your buyer clients to make sure they understand, listen, you're going to be out shopping for houses, and I encourage you to do that. But please understand that when you're clicking on these links, it's not like you're just going to the listing broker necessarily, or it creates these relationship struggles that ultimately might harm your ability to get the house that you think you want, right? And so, Damian, have you been dealing with any of this at all?
Yeah, we've had several of these, and I want to look at it from the other side too, because so the buyer, when they're out there clicking on websites and everything, they don't realize that when they click on see the house now, or for more information, click here, or whatever the case may be, that it's part of a marketing program that sends them through to whatever the website's site is, to somebody that advertises on their website that's not even the listing broker. It's a lead. I mean, that's what they're marketing, and that's what they're doing, is they're creating these leads for these brokers. And what I've seen several times is brokers get these leads, and then they don't ask the question, are you working with somebody? Have you signed a buyer listing contract? And now if you're not asking those questions, that leads to another host of potential problems. Disclosure of brokerage relationships. Did you ask the question about sign crossing? So if you're advertising with some of these websites, you have to take some diligence as far as making sure that you're asking the questions of the buyer to protect yourself too, because I just don't see an arbitration panel looking at somebody that got a lead off of one of these websites, and then they went and showed them the house, and then that buyer went back to their broker that they were true to, and all of a sudden saying, well, I showed the property, therefore I should be procuring cause. I don't see that happening. So number one, instead of wasting your time, you should be having those conversations. But number two, and Scott, you know better than me. I mean, I'm a lawyer. We don't really do a lot of ethics, but it seems to me like maybe that's an ethics issue too, if you're not at least having the conversation with the buyer about whether they're working with somebody or not.
Yeah, ethics issue, sign crossing kind of license law potentially issue. You do need to make appropriate inquiry. And I don't disagree with Damian in the sense that arbitration panels, I think, generally will struggle with trying to award a commission to a broker who just merely shown the property. And in fact, this concept of what we used to call the threshold rule, right? The broker who originally brings the buyer across the threshold somehow has procured that sale. That in and of itself is not to be like an exclusive basis for an award. In other words, that if that's all that you got, that's probably not enough and shouldn't be enough. But if you're sitting in an arbitration to get your commission, you're talking about a deal that's closed several months ago. You've now had to respond or make an arbitration request as a broker. And while you eventually may win, it's not going to feel like showing up at the closing table and collecting your commission check as you should have or could have if things had been done properly. So, and I think a lot of your buyers don't understand, and I would say the marketing is good enough and maybe is confusing enough that an unsuspecting buyer could easily click. I also do think some of your buyers do know and they just don't care. And this is the value add, the value proposition that it's so helpful and important to articulate, particularly through the creation, hopefully, of an agency relationship, through the exclusive right agreement, and the things that you can do as an agent for your buyer that you couldn't do by just giving them a TB disclosure at the beginning of a transaction. And that value is something that I think most buyers don't fully understand in terms of the distinction between acting as an agent and acting as a TB. And that might be a helpful piece of the overall sales pitch as you're presenting them with an exclusive right to buy contract. So anything else on that, Damian, or are you ready to move on?
I'm ready to move on.
Okay. What's the next thing here? You want to talk a little bit about transaction coordinators? This has been a big issue with the Division of Real Estate. The Real Estate Commission actually just put at their, what was that, October meeting at the beginning of October. It was one of the agenda items that the commissioners had asked the division to put on, and they wanted to kind of chat about a little bit about the implications of it. So lots of issues related to use of transaction coordinators. I have seen on the hotline a lot of calls, usually coming from a frustrated broker, either on the buy side or the sell side, who has gotten into a contract, and then the broker on the other side of the deal will basically say, hey, by the way, here's my transaction coordinator, run everything through them, right? Don't bother me with stuff. Now, we should all be so fortunate to be that successful and busy as a broker that we can get a deal under contract and then just sort of walk away. But there's a ton of implications to that. And the concept of use of transaction coordinators has now gotten the commission's eye, and therefore the division has been instructed to do some analysis of it. So Damian, I'll let you talk maybe a little bit about the kind of concepts of being licensed and unlicensed as using transaction coordinators, and I'll chime in where appropriate.
Yeah, and it's more than just, they did more than ask the division to investigate. They actually went so far as to tell the division to look at a position statement on coordinators. And so my guess is that in the December meeting that we have coming up, my guess is they're going to reevaluate Commission Position 20, which has to do with personal assistance. Because at least from my perspective, and Scott, you and I have talked about this several times, but there's really no difference between a personal assistant or a transaction coordinator. They're assistants. What really the question is are they licensed or are they not licensed? And if they're licensed, what activities are they performing? And do they have a right to perform those activities? So, when you're talking coordinators, you see transaction coordinators that advertise, oh, I'm licensed. Well, that's nice. But if they're acting as a licensed coordinator or licensed assistant, then what that means is that they have to have a working relationship. In other words, they have to be co-listed with every single one of your listings in order to provide that licensed activity. They can't just say, I'm licensed, therefore I can negotiate an inspection resolution. They have to have a working relationship, just like any other broker who is performing real estate brokerage services. My concern with licensed transaction coordinators that work with more than one team or broker is that it could create a real conflict. So let's say that I have Michael as my licensed transaction coordinator, and I decide, okay, I want her doing licensed activities. So I name her on all of my listing contracts, which gets even more complicated if she's not in the same brokerage firm as me. Now we have co-listings and two brokerage firms involved, and she's a transaction coordinator that maybe not doing all the stuff, but just doing some, but now she's got to run it through a brokerage firm. And then she she contracts with Scott as on the other side. So let's say I represent the seller, Scott represents the buyer. She's a transaction coordinator for them, doing license activity for Scott. Well, by virtue of the fact that she's on his listing contracts and my listing contracts, we've now all got to be transaction coordinator or a transaction broker. Our relationships just got all screwed up for trying to have a transaction coordinator perform licensed activities. My suggestion is to leave transaction coordinators, even if they're licensed, as unlicensed assistants or unlicensed transaction coordinators, just because that way they can work for both of us, but it doesn't mess up our relationship with our clients. Did that make sense, Scott, or am I speaking Farsi?
No, that made it makes perfect sense, and I agree with you. I think the big issue with licensed TCs, as Damian points out, is when they're not necessarily at your brokerage firm or they're not dedicated to your brokerage team. I mean, if you've got a licensed TC that's on your brokerage team and they're doing only stuff for you, hey, that's great. I mean, they can handle, brokerage functions. You don't get into some of the payment issues and that's not necessarily state law, but that's federal law under RESPA, because if you've got an unlicensed TC now and you're paying them based on a success fee based on a closing, well, now you've got potentially RESPA issues. If there's a federally related mortgage loan that's involved in the transaction and it's for a residential property, you could have federal law violations based on how you're paying people. So that's another side of things. But I do think being an unlicensed TC is a better way to handle somebody who is not at your brokerage firm, not working exclusively on your team, and now it's essentially a personal assistant who can do some of the stuff. But in that case, what they can't do is some of the more advanced or perform any brokerage functions on behalf of the transaction. And so there's this, it becomes very interesting because there's benefits and detriments to being one or the other. And it's kind of hard to come up with a way to really incorporate, particularly somebody who's outside of your brokerage office, who might be handling TC services as a licensee for multiple brokerage firms. And then the other piece of that I get into is that somebody will have their brokerage license hung at some brokerage office, and then they're doing this kind of side business of managing transactions as a licensed TC. Well, that creates first of all, if I'm an employing broker, you are not going to be a TC for anybody else. Like that's just as part of my office policy. If you want your license hung with me, you're going to be doing brokerage functions for me and not doing any brokerage functions or quasi even brokerage functions for some other brokerage firm or some other brokerage office or brokerage individual, because that potentially invokes my errors and omissions concern. It potentially creates a lot of co-listings, essentially, as Damian was alluding to, potentially conflicts of interest, all kinds of struggles with that. And so anyhow, the point of bringing this all up is the real estate commissioner's eyes, I think, have been opened to these based on a lot of people that are really aggressively using TCs, particularly in this really busy marketplace, right? They want to get on to the next deal and get the next deal under contract. And I get that, but you got to make sure that you're sort of crossing your T's and dotting your I's as it relates to the relationship that you're having with these people that are working with you.
Yeah, I'll tell you that if you have TCs or assistants, I mean, there's a host of issues. Scott alluded to RESPA receiving commission. That's also under license law. If it's a portion of commission that it has to go through somebody's brokerage firm. And I see we got a couple of questions, Scott, so maybe we should attack these too. There's also issues with payment because, the IRS says that real estate brokers receiving commission from a brokerage firm are statutorily independent contractors under section, I think it's 3508. But yet once you have an unlicensed person or somebody acting as an unlicensed assistant, whether they have a license or not, question is, are they a W-2 employee? Or can you treat them as an independent contractor because they're working for multiple people? I mean, there's just a host of issues when you're dealing with this, and you really need to investigate as to how that person is acting, what duties they're performing, and which box they fall into as independent contractor or employee. It's not an easy subject. It really isn't.
Yeah. I love that Damian just dropped the IRS code section on us here. That's quite impressive.
I've memorized it. It's fun.
I know.
We got two questions here on TCs that I think is appropriate real quick. So the first one, Scott, is if my TC has a real estate license, but only does unlicensed work for me, what type of disclosure do I need to have?
Well, I would probably have something that essentially, so is this an in-office, well, I'll just touch on them both.
He's saying that it only works for him. So I'm assuming it doesn't really even matter if it's in office or not. If this person is his only assistant, he's wondering, should he have some kind of disclosure?
You could have some language in there that essentially says that, broker's authorized to share information with this individual. But if it's just your personal assistant, then you are ultimately liable for 100% of everything that goes on. If they were to cause some breach of data or breach of confidentiality, if they were to screw something up on the transaction, they're not licensed, so they don't have liability. They don't have E&O coverage that would extend to them. 100% of it flows through you. And so the only thing in terms of, and I don't be curious to hear if Damian thinks it's required. I don't think it would be required, but it might be a best practice to have in the exclusive right to sell or to buy something that makes reference to this person, that they're an unlicensed assistant to you, or in that case, they're essentially an unlicensed assistant to you, even though they have a license, they're not performing brokerage functions, and that you are authorized to share information related to the transaction with them. Any thoughts there?
Yeah, I agree entirely. I'm not sure it's required, but to me, best practice is to disclose in the listing contract that this unlicensed person will be receiving confidential information. I mean, that's, we have this confidentiality in our uniform duties that we have to perform. And so at least getting permission, or at least stating that you're going to be sharing it with somebody, then that's what I would do. I see Bill said that they also have other clients in the office. I would have an agreement with, if somebody has multiple clients in the office, you need to have some kind of confidentiality agreement with your assistant or your coordinator that says that they will not release confidential information about your clients to one of the other brokers or somebody else that they're working with. You really should have an agreement with them too that says what they can and can't do, which brings up the next question that Ann Skinner has that says, can you give examples of things that unlicensed TCs should avoid when handling transactions so they don't cross into licensed functions? Commission position 20 is actually very, very well done. I think that's probably where it's going to get updated, but for now, it does give you a blueprint of some of the things that they're saying unlicensed people can do without crossing that line. So hopefully it'll be updated, and maybe they'll add some other things into it. But right now, that's where I would go to look at.
Yeah, it's, as Damian mentioned, I reached back as soon as I saw that question and grabbed the handy dandy manual. But CP20, it specifically enumerates 9 different things that they can do. You can speak to the reciprocal of that. What they can't do is they can't perform any brokerage function. Damian's got his manual handy as well.
I want to make sure I have mine too. I don't want you to be the only one that can grab a manual at your fingertips.
Yeah, that's true. Fair enough. But anyhow, they're sort of ministerial tasks: perform clerical duties, including gathering information for a listing, complete forms prepared for and as directed by the broker. They cannot independently draft legal documents such as listing or sales contracts. They can't offer opinions, advice, or interpretations on documents. So great resource, CP20, and I agree with Damian. I think that that's ultimately where we will probably get a more expansive consideration of transaction coordinator / personal assistant / there's another term that I've heard you use before, Damian, for somebody in that world.
Assistants, bookkeepers, unlicensed on-site managers. I mean, there's a whole host of people that help brokers doing these tasks, and it's good. I mean, these are good people to help you guys, but they but yeah, it's anybody that's helping you with your business, that's interacting with your paperwork in particular, but also potentially with your clients, that you got to know what they're doing.
Yeah.
You want to talk about salary versus per deal, or you want me to handle that one?
Well, I think we've kind of talked a little bit about it, but I mean, the salary certainly works. I mean, you can pay somebody a salary if they're an employee. Now, you've got to address all of the other federal and state law requirements related to having an employee, including withholdings and, potentially insurance and all of that other good stuff. And there is not a RESPA issue if that's the case. The problem is if it's per deal. And I think, I've heard Damian and I have talked about it, and I've heard him speak to the fact that, if you want to give somebody a file and say, hey, I'm going to give you $500 for every file that I give you, then I think that works for an unlicensed TC. If you say, if you're only going to give them $500 for every file that closes, then I think that's where you get into the splitting of commissions that would be precluded by federal law, specifically RESPA. Would you agree with that, Damian?
No, I agree entirely. That's the biggest risk to me I see with the TCs paying them by file is that, brokers don't want to pay unless the deal closes. And the minute you make it based on success of the transaction, that starts to sound like commission, starts to sound like RESPA issues. You'd be much better off giving them a per file fee, regardless of whether it closes or not. And the reality is this. The real estate commission requires you to keep all files, whether it closes or not. So even the deals that do not close, you're still supposed to have a transaction file on. So paying them per file, even for the ones that don't close, really kind of makes sense because it's still meeting your compliance obligations for the real estate commission.
Yeah. I think Bill just kind of clarified his question. I think we answered that in terms of that. There's another question on TCs in the chat. It says, so are virtual TCs that you pay per transaction that act as an unlicensed assistant okay? I think that's kind of what we were just talking about. I mean, if you're paying them per transaction, then if you're paying them for the transaction, regardless of whether it closes or doesn't, then they're not participating in a success fee or a commission under RESPA. If you're paying them for transactions that close, then you would be, and you could potentially have some issues there. I see Christy linked the link to CP20. Thank you for doing that. That's helpful. That's a Google Drive link, but that's directly to the Division of Real Estate's website. For those of you that don't have your handy dandy yellow manual this year, you can go there and you can see the CP20. And I think it's a good discussion of what brokerage activity versus non-brokerage activity. There's a statute as well, Damian, that defines, you maybe know it off the top of your head, but it defines what brokerage activities are, 1210 something someplace there. And
yeah, I thought it was 10.
I'll let him, kept him busy with something to shut him up for a minute or two so he can.
Thanks.
He can, but so I think the point is that reading CP20 for a description of what the commission's perspective on what an unlicensed individual can do, and then reading the license law statute related to a brokerage function, the marriage of the two of those gives you a very good sense of what a brokerage activity is and somebody can do versus what somebody who is unlicensed can't do. Did you get that?
1210-201 has the definition of what a real estate broker is.
1210-201. So Christy, if you can post
6A if you want specifically.
There it is. Christy, if you want to post a link to that Colorado revised statute, that would be fantastic as well. Might be a little bit harder to get to, but it is available out there. Okay, I think we've got our questions on TCs. Next topic, you want to talk about teams a little bit, Damian?
Oh yeah, I love teams. That'll be even as much fun as TCs, talking about how confusing they are.
Well, this was kind of one of the things that you had mentioned, so I'll let you kick it off and we can start the discussion there.
Well, so we're still seeing a lot of concern questions about teams, and I'm sure you guys have seen the annual commission update course. It talks about advertising and all that, but one of the things that's come up most recently that I'm hoping we're going to get guidance on is what happens. So let's say Scott and I are on a team, and I decide to list my home. And Scott decides to buy it, or Scott's brother decides to buy it. And there's a conflict in our rules because what the rules say is that if we're on a team, then we have to be named as the designated brokers in all of our listing contracts, which means that Scott has to be named as a designated broker on my listing contract, and I have to be named as a designated broker on his listing contract. But now it's colliding with the fact that I'm a principal. So if I'm a principal, it's hard for me to be TB, but if Scott has the buyer that is his brother, I want you guys to see where it gets confusing with teams. And if you're on a team, you got to be a lot more careful about your relationships with your clients and when you convert, when you don't convert, and knowing what the relationships are, knowing what the conflict of interest is. That's been this has come up several times for me, and I don't know what the division's going to do with it, but I'm hoping they'll address it at some point.
Yeah, I'm surprised. It's amazing how frequently the scenario or a scenario similar to the one you've just described comes up, where, amazingly, you've got your hands all over, like, your buyer's your brother, your buyer's your best friend, your buyer is your kid. I mean, I get those kind of all the time, and it really does create some tension and confusion with regard to how then the team has to act, because I think, as Damian mentioned, you can't sort of step in and out of a team based on a deal. You're either on a team or you're not on a team. And so I think, as we talked about, as well as you guys would have seen as you took the 4-hour update course at some point this year, teams was a big topic in there. There was rulemaking as the new yellow commission manual got promulgated January 1st of this year, and as all of the rules got sort of recodified, let's say, into chapters, a lot of that recodification included a lot of updates and references to team advertising, to team use, to that difficulty of trying to be, or impossibility really, of trying to have two team members be on the same transaction, one working with the buyer and one working with the seller, which we know it just doesn't work if they're going to try and be agents. They both have to be TCs. And then if you throw in the personal relationship that Damian describes, that really forces an odd situation into not just the individual who happens to be the brother of the buyer or sibling of the buyer or the child of the buyer, whatever it is, but to the whole team as it relates to that buyer. So be mindful of that. Was there any other pieces of this you want to talk about, Damian?
No, just strictly people, and this goes for even when it's not teams, but you should decide if you're going to buy a listing before you list it, because when you decide that you're going to buy a listing after you've listed it, it just creates a host of problems that, whether you're on a team or not on a team, it just creates conflict of interest and all sorts of things. So, be cognizant of, if you're in the market of buying something, when you go meet with a seller, talk to them about, if you're interested in it, talk to them at that time about buying it before you've established a working relationship, period. Or if you're on a team, maybe have a conversation with your team about it before you buy it or before you take the listing, so that you're not creating this conflict.
Yeah.
So.
There's a question, and I'll let you handle it, Damian, but keep your transaction history whether or not it closes, question mark. Does that mean keeping offers that never get accepted? CTM allows buyer agents to withdraw those offers. How do you deal with that if the offer is no longer within CTM? Am I supposed to print and save every offer I get so the buyer's agent cannot hide it at a later date? I know you've got some thoughts there, Damian.
Oh, I have lots of thoughts on this. So first of all, when I think they're talking about transactions that fail, I think they're talking about if you had a buyer listing contract and the buyer ultimately decided not to buy, then you should have copies of anything that you made from them, as well as a seller listing contract. I think you should have as well. Regardless, it is always best practice to keep copies if you're the listing broker of any offers that you got in, because you should have copies of those contracts, because we've seen claims where the seller says, oh, they never presented this offer. Oh, they never told me about this. They never told me this, because the buyer doesn't get the property and they file a complaint saying the broker never conveyed my offer to the seller, or I have no proof that they conveyed the offer to the seller. And it's really hard to defend those claims when you don't have copies of the contracts. I mean, you say, oh yeah, I presented it, but I can't find it. That doesn't play real well to investigators. That's not what they want to hear. So I would keep a copy of everything. And I know that one of the limitations, or what I view as a limitation of CTM, is the fact that people can withdraw offers and you can't see it again. Every time you get an offer in, I would turn it into a PDF and put it into your transaction file or any kind of document, whether it's accepted or not. You want to have whatever shows the paper trail of the transaction, whether it was amend extends that didn't get accepted, or resolutions that didn't get accepted, or contracts that didn't get accepted. You really should have all that in your transaction file. It just makes it a lot easier for the lawyers to defend you when you get a complaint that somebody claims that you didn't do your job.
Yeah, I would agree that is absolutely a best practice. I don't know. I do want to clarify this because I'm not exactly sure myself, but the Division of Real Estate would have you maintain it as a transaction record, not specifically though, at least according to them. Now, let's delineate between what's a best practice from a civil liability or from what your E&O provider is going to thank you for if you ever have to defend you, versus from what the letter of the law is. And I think in terms of record maintenance, they want they would want your transaction or your items from a transaction file for a transaction that actually is either closes or that doesn't close. Well, how do I say this? So if you've got a listing as an example, and you never sell the listing, you would have to keep your listing agreement with that party. You'd have to keep any of the records that are included on the transaction file maintenance list. But I don't know that they're going to anticipate that you have every single offer. That's part of their rule.
I don't know as you need every single offer, but you do need offers that were accepted and then failed. So, so if you have a contract that the seller accepted and you get to inspection and the buyer terminates and the money's released, you need a copy of the earnest money release. You need a copy of the contract. That failed transaction that was accepted by your client does need to be included in your transaction file. I'm not sure if they require all of the ones that were presented, but I'll tell you from my perspective, just keep them. Just, PDF them and keep them and throw them in your file. It just, I can't tell you how many times those have been the things that have exonerated a broker because they were able to show that they did perform their duties.
Yeah, and I 100% agree with that statement. The more stuff you've got in your transaction file, the better off you're going to be. There's just no question about it. And Damian, who actually does defend brokers in matters, take it from him, because I couldn't agree more that the more full your transaction file is, the better off you're going to be as you're trying to address any either regulatory complaints to the Division of Real Estate, civil complaints, whatever have you. It's better to have. The other thing I'm going to just point out about that question, and I pointed out because I think it's important. I think there's a lot of misconceptions. CTM may be a perfectly appropriate document management system. It may also not be. I mean, in other words, the division, it would not be exculpatory if CTM were to go bye-bye, or if they had a colossal disaster where they lost all their records, and the division was to say to you, well, we want this file or that file, and you say, well, I kept them all on CTM, and CTM had a problem and they went away. Like, that's not a defense. And that's very clearly and explicitly stated by Marcia Waters, that couldn't be more clear. So be cautious if you're 100% relying on any one third-party source for your record maintenance and transaction files.
Yeah, likewise, CTM, and I think they do a lot of things really, really well. So don't take me as bashing them, but I do think that, sometimes employing brokers rely on the fact that the broker has all their documents in CTM, and then if the broker leaves, that employing broker may not have access to those documents anymore. So there's a lot of different issues there with whatever document database you're using or wherever you're using to maintain your files. You're really better off having everything in a central location that you can control.
Yeah. Okay, so I'm going to move to a question here, and it's funny because the question is something that I had on my notes because specific to your marketplace, because somebody had said, hey, would you speak to this a little bit? And that is, can you also talk to the multiple offers and professional courtesy of letting all parties know about the outcome? So I am getting more of this, and one of the things that, so a couple of years ago, and Damian and I both are in agreement here on this, we eliminated the countered and rejected boxes from the very bottom of the contract.
Thank God.
and Damian, and I agree with him here 100%. He says because they were stupid is his legal answer for why that got eliminated. But I agree with him completely. Obviously, the entire forms committee became in agreement, but I still, to this day, I'll get people that call a hotline that don't know that I have anything to do with the forms committee or anything else. They'll say, I don't know why they removed the countered and rejected boxes, and now I don't know if anything is going to get accepted or if it got presented or what's my evidence. And so what I'll end up saying to people is, listen, at no point in time does a seller owe anything to the buyer or to an offering buyer or to the buyer's agent or to anybody. In other words, the seller never had to check a box. And in fact, one of the reasons that we took it out was because I was getting a lot more, I think we were all getting a lot more misformation or mistaken formation of contract, because a seller who doesn't know how to use CTM was going in to check rejected or countered, and they ended up executing the offer. And now they've got a contract when they didn't mean to form a contract, and that was creating problems. But so the issue about this concept of, how do we know our offer is presented? Well, that was never the appropriate place to get it, from the rejected box on the old contract. So it is good that that went away. So now we get into the realtor world here and code of ethics. And so there is an article in the code of ethics, a standard of practice, I should say, supporting, I forget if it's Article 2 or Article 3, but basically and this was actually just passed by NAR simultaneously, completely coincidental, but simultaneously to being removed, to the countered and rejected boxes being removed. And so now there is a standard of practice under Article, I think 2 or 3, that basically says that if you're a listing broker and you receive a request from a cooperating broker to confirm in writing that the offer was presented, then you're compelled under the code of ethics to confirm in writing via an email saying, hey, please accept this as confirmation that I presented your offer to my seller. All right. And that's a pretty good backup plan. And for a realtor who refuses to do that, first of all, if they do it and they've written fraudulently that they did when they didn't, well, that could lead to some serious problems at the Division of Real Estate, among other places. But if they refuse to do it, then you've got a very easy sort of slam dunk ethics violation that you could file a code of ethics complaint against them. But to my mind, the bigger issue here is you guys got to do business together. You're working in a market that is pretty defined and distinct. And so the common or simple courtesy of being a listing broker and confirming, or being willing to confirm in writing, or letting parties know, hey, we reviewed all the offers, you didn't win, right? Those of you who work with sellers also know, from hopefully working with buyers at some point as well, there's a lot of angst and anxiety and excitement and everything else as a buyer writing up a contract on real estate. It's a big deal. And so a simple professional courtesy of confirming that something has been presented, that your offer at least had the consideration of the seller, to me, it seems like it's a 2-second ask for the seller's, for the listing agent. And it's an incredibly easy professional courtesy to accommodate, not only to your co-broker out there who took the time to write an offer and present it to you, but also that broker's buyer who is, stressed out and excited and wants to get a property. So, Damian?
Yeah, I think it's important. I mean, the other thing is that at some point you may have the seller this time, but you might have the buyer next time. And I would extend the same courtesy that you would expect a broker to show you and your client to other people. I mean, this is just common courtesy, and this is our industry. We should be acting courteous towards the people that work in this industry with us. Also, not every first contract survives. Not every first contract makes it to closing. And if you treat a buyer terrible, or buyer broker terrible at the beginning because you accepted a different offer, and then the one that you accepted fails, they may not want to talk to you anymore. And, having that courtesy to them, at least, they might, if the first offer fails, you can go back and talk to them about, hey, this offer failed. Would you like to make another offer? And if you treat them with respect, and they haven't offered on something else, you might actually be able to put that deal back together. So, this is your industry. Treat it like that. It's your career. It's your profession.
Yeah, 100% agree. And particularly in a small market, relatively small market like you guys are in, it's just that, you guys are always going to be bumping up against each other. Have respect for each other and each other's clients, and that'll make things run a lot more smoothly. All right. What else do we have here, Damian? You want to talk about, let's talk about the NAR lawsuit, the antitrust stuff that you guys heard from both of us probably last year about that. So as you guys know, there's 2 lawsuits that are floating around. That there were actually a couple that have been combined now, but it's down to 2. There's a federal class action lawsuit that's been initiated in, I forget what district, but in federal court in Missouri, and then another in federal court in Illinois. And these are district court federal lawsuits based in a theory of antitrust, violation of the Sherman Antitrust Act. And the defendants in the lawsuit are NAR is kind of the flagship defendant. And then their co-defendants are Remax, Keller Williams, Home Services, and Realogy. I think I got that right. But these are the franchisors. These are the holding companies. So all of them. The concept is sellers have been harmed over the last many years, generations even, by this concept of an offer to compensate through the MLS, and that a listing broker has to agree to compensate a cooperating buyer's broker some dollar amount or some percentage of a transaction. So before I even go any further, I want to say that if you guys are going to ask questions, we're not using numbers, we're not using dollars, we're not using percentages. Please don't ask questions that allude to any of that stuff, because that goes directly against everything that we're talking about here. So the short of it is since we all last spoke on this topic, probably about a year ago, NAR and their co-defendants responded to the lawsuit and request a dismissal, request the judge in Missouri and the judge in Illinois to dismiss the lawsuits, no merit, et cetera. And both of those motions to dismiss have been denied. It was much earlier this year in the Missouri case by the Missouri judge, and in the Illinois case, it was just actually a couple of weeks ago. And both judges basically said, we're not going to dismiss these lawsuits. These things are going to move forward. And so what all of this is getting to, and you guys can, it's all very public, there's a lot of information. NAR's got some updates on their website and some responses to it. My cautionary point, and I think Damian's will be as well, is that specifically the reasons I'm talking about, like this concept of using these market commissions or using nomenclature that's, well, that's our standard fee, or that's our normal commission, or that's that's what we pay in Breckenridge for a cooperating buyer's agent. Those dialogues, those conversations they can't be happening. Don't have them, because there really is no such thing as a market commission. Your Summit MLS does say that you have to offer as a listing some dollar amount or some percentage. Well, that could be 1 penny. It could be 0.0000001%. Ultimately, commissions are at the election of the seller, and you have to let your sellers decide. So the last thing I'll say, and then I'll let Damian talk, is I think a great way to have conversations with your sellers about this is about when you go to sit down with your seller at a listing. When you go to sit down with your seller at a listing appointment, and you go to them, what do you bring? You bring usually a spreadsheet, and you're armed with these are the sales comps. This is what I'm recommending you price it at based on these deals. And this is what's currently on the market. And this is what's sold recently. And this is how many square feet things were. Well, add another column to that spreadsheet that says, this is what those sellers offered cooperating brokers as compensation, right? And those numbers may look roughly the same, but they also may be some really significant outliers too, just depending on what the situation were. And then allow your sellers to be selecting what compensation they want you, through your exclusive right to sell listing agreement, to be offering to the marketplace. But don't be having conversations about average commissions even. And can you say, if somebody asks a question here, can we say average commission? I think, again, I would be very cautious in assigning something that is a specific value to what your market you think is gonna expect. If you're using that column and speaking in terms of facts rather than speculation or conjecture, then your seller is going to be able to look and go, okay, well, this one paid this, and that one paid that, and this one paid this. Well, I could offer nothing if I want, or I could offer 1 penny if I would like to, and that may have an impact on the volume or velocity of transactions that are coming in the door. Who knows? But ultimately, it's up to your seller to make that. So I'll get off my soapbox, Damian. I know you've got some additional or some supplemental thoughts on this.
Well, I want to talk from the perspective of the buyer broker. And the reason I want to talk from the perspective of the buyer broker is because this antitrust lawsuit could have an impact on, what's being offered, what compensation is out there. Who knows what's going to do to MLS offers of compensation, there's all sorts of different places this could or could not go. But at the end of the day, buyer brokers need to be having that conversation with their buyers and not just, defaulting to whatever happens to be offered in the MLS. You should be having a conversation about compensation, what you do for your job, how you perform your job, what you get paid. This is your profession. the amount of compensation that you believe is fair for the services that you provide. And you shouldn't be afraid to ask them to pay for it if for some reason a seller doesn't offer it. I don't know where the antitrust lawsuit's going to end up. I don't know what impact it's going to have, but buyer brokers need to start working on their value propositions. You need to have a value proposition that says, this is what I get paid. And if for some reason I can't get a contribution from somebody else, that the buyer should be willing to pay it, or the buyer should be willing to ask the seller to pay for it in a contract. So keep in mind that this antitrust lawsuit, while it's very important from listing brokers and the conversations they're having with the sellers, it's also important from the buyer broker's perspective and the conversations you're having with your buyers, particularly as we see what fallout, if any, there could be in our industry. Even if there's no fallout from antitrust, it's still a good conversation for buyer brokers to be having about their value propositions and the fact that you do this for a living and you guys offer a lot of value to buyers. And it's about time you start explaining that to them.
Well said. I couldn't agree more. And I've been saying recently that there's three kinds of brokers out there. There's those that first of all, there's those that don't have a value proposition. They're cruddy brokers. They don't provide value. They don't add value to the transaction. Those brokers, I think, as the market condenses a little bit, will eventually go away. The next type of broker is those who have a value proposition and are really good at articulating that value proposition. Those are the ones that thrive now, and they will always thrive because they bring value to the table and they know how to sell and explain their value and push their value. And then there's this other category that is this, I'm most empathetic to. Those are the ones that have value, but they're not great at selling or articulating their value proposition. And those are the ones that, you got to improve that sales pitch and be able to articulate it better. It's going to get you more exclusive right agreements signed overall, which is, as we talked about earlier, super important. It's going to give you the ability to drive what your commission is through your buyer rather than trying to rely on, as Damian alluded to, the offer of compensation exclusively. So be thinking about all that stuff. One question, can you recommend a co-op commission as long as you back it up with facts like a spreadsheet, or do you need to totally stay away from that? I mean, I think you let your seller decide the commission. Let them know that they do not have to offer any commission. I mean, again, what your MLS rules would say is you can tell your seller, listen, I'll kick in a penny of my own commission to offer to make your property eligible for compensation or eligible for listing on the MLS, and you don't have to offer any compensation. Again, there's a lot of good reasons as a broker from a standard of care that you need to make sure your sellers understand the implications of not offering commission, right? But even that conversation is a bit nuanced and difficult because in all candor, a buyer's agent couldn't, under license law or under their fiduciary or anywhere else, not show properties that don't offer compensation, right? In other words, that would be a breach of your uniform and fiduciary duties if you were not providing information or access to properties that offered no commission. So it's a touchy conversation, but the biggest point is that I think as an industry, we've gotten a little bit lazy because of the required offer of compensation and haven't worked on our value proposition, or at least refining that and articulating that, and haven't worried about getting exclusive right agreements signed because we just figure we're going to get paid through the MLS and don't have to worry about the buyer. Well, that doesn't address the buyer who's going to cheat on you, who's going to go work with somebody else, who's going to go meet, click on a button and go meet another broker and see the property as we talked about earlier. I mean, all of those things. So anyhow, all right, what's the last topic here, Damian? Should we open this can of worms of right of first refusals? There's two marketplaces that Damian and I always get a chuckle about, and I get hotline calls all the time on it and I don't even have to know the broker. I can say, are you in, I think I can say this, are you in Aspen, or are you in Summit, or are you in Aspen essentially, or at the Aspen Glenwood MLS?
Vale.
Yeah, Vale's actually got a little bit, but I find I get more calls from Summit or specifically Aspen. Anyhow, these are these condos, these generally older condos that have these old and often poorly written exclusive, right of first refusal. So property goes on the market, the seller is bound under the HOA documents or association rules and regs or bylaws or wherever it comes from to offer that property or give a right of first refusal to every other owner within that property. Well, that leads to some interesting situations, specifically one where a broker brings an offer to that property. Sorry, there was a question that popped up, but where somebody brings an offer to that property, and then that offer is taken back to the other owners, and then one of the other owners accepts or acts on that offer. That broker wants that, or that buyer, the buyer that ultimately accepts the contract, they want to start and work with their own broker. So who gets paid in that situation? Damian, who gets paid?
Which side am I on? Mine.
You're representing broker A, the broker who wrote the original offer.
Well, obviously he should get paid then.
Of course.
And the reason should be is because, but for the fact that he brought an offer, there would not have been another offer. There wouldn't have been a closing. Therefore, he was the procuring cause that caused the sale of the property. Therefore, he should get paid.
Okay. Well, so I'll take the side of the broker who represents buyer number 2, or more specifically, the listing broker, because remember, it's the listing broker who's making the offer of compensation through the MLS, and it's a unilateral offer of compensation. But if I'm the listing broker, my response to that would be, listen, I don't think I have to pay the first broker A, who brings the offer, because I disclose through the MLS, I check the box, or I put yes, there is a right of first refusal applicable. And so because of that, my unilateral offer of compensation to my other MLS participants was contingent on that, on the right of first refusal. Therefore, it was a unilateral offer of compensation contingent upon nobody else accepting this offer. It's not some third party not springing up. And as long as I've disclosed that through the MLS, now I'm taking a side here because I don't know that there's a magic answer, but I'm illustrating my side, one side of this, which would be, I owe compensation to broker B, the second broker who represented the actual buyer of the property, because I didn't make a full unilateral offer of compensation to broker number 1 because of my caveat of right of first refusal. So
if I'm representing the listing broker, I will tell you what I would do is say, we're going to freeze the commission, and we're going to let broker A and broker B go duke it out in an arbitration. And we're going to let them figure out who's the procuring cause, because I don't want to have to give money to either of them if it turns out the other one was. Just from the listing broker's perspective, that would be what I would advise a client. But you're right, broker B, hey, it was contingent upon this, and I closed, and I helped write the contract, and I did all these other things. So this is not easy.
No, it's not easy. We actually see car arbitrations related to this, and there's not a 100% answer. I can't give you, yes, this person is always going to win, or no, this person is not always going to win. But it's an interesting discussion. So Michael's saying we're going to wrap it up here in about a minute and a half. And I know that you guys probably have some thoughts on this and want to have some questions, but here's what I think Damian and I can both agree on, or I know we both agree on, is your MLS has every right to rule make around this, right? You could make some decisions about, or your MLS board could pass rules that would dictate in that situation how commissions are going to be handled. And I might encourage you to do that, because I do think it would solve a lot of disputes that are brewing out there. Damian, you can have the last word here.
I get the last word. Well, I agree. I mean, the problem with the way it is now is that it's just too ambiguous. I mean, it's too easy to argue one side or the other as far as who's procuring cause, who's entitled to the compensation. Listing brokers paying out 2 commissions potentially if they paid out one and it turned out the other one was able to argue that they were entitled to it. But there's a multitude of different ways to handle this. If the MLS would take up rulemaking, they could decide it's either broker A that gets it in every single case, or it's broker B that gets it, or they split it, or there's an allocation of it. I mean, there's ways to make this so that it's fair, but more importantly, that everybody knows what the rules are when, as Scott pointed out, the box is checked that says it's subject to a first right of refusal. That would be the disclosure that says these rules now apply. So I would really encourage you guys to talk to your MLS about finding a way to come up with something as a board that makes sense for everybody, so then you have a set of rules to play by. That's all I got.
There you go. All right. Well, I will, there's one question. It's kind of a long one. I think if I'm trying to read it, but I think to get to the gist of it, this is in the exclusive right to buy contract in terms of which box you're checking. And just, I'm paraphrasing, but buyer will pay, seller may pay. buyer will not pay, no obligation whatsoever. And then there's a seller, seller may not pay, I think is what the third one is. In other words, the buyer is definitely going to pay. So, which is rarely ever, if ever checked, I would imagine. The point being here is that I know your buyers don't want to check the box that they're going to pay. They don't want to have an obligation. They want to, everything's free, right? Free for your buyer services. But that doesn't fully recognize your value proposition, for one. And for two, it also doesn't really allow you to ask in the contract for the seller to compensate you whatever the buyer has stepped up to compensate you for. And so here's one possibility: to the extent that the buyer has checked the box, buyer will not pay. Buyer shall have no obligation to pay. That your buyer checked that box in the original listing agreement, and then you come up and there's a property that's not offering you the commission that you have negotiated for. Then you could always
go. You could say a penny. There was an offer in compensation, a penny, and you wanted more.
Yeah, you wanted more than the penny. You could go back to your buyer and do an amend extend to the exclusive right to buy brokerage agreement, and you could shift the obligation to the buyer, and then the buyer, through the contract, through their offer to the seller, then could request that the seller pay, or the listing brokerage firm pay your, I guess it'd be the seller essentially would pay your brokerage commission through the contract. So you could address it that way. None of it's ideal, but anyhow, I'm going to let it go with that, I think, because we've already gone over time. Elliot Eisenberg is coming up at 1 o'clock, and Damian, have you seen Elliot?
I have, yeah.
Yeah, he's. I'm sure most of you guys have seen him. If you haven't, he's pretty fantastic. I'm actually going to hang around because I enjoy his market updates. But I know he's going to be on at 1 o'clock till 2 o'clock. And Michael, is there anything else, or Sarah, anything else that we need to do here?
From you guys, we just want to say thank you so much. This was really helpful to me, and so I'm sure that everybody else who got to see it, it was great too. But we're just gonna slow transition into Elliot. We're inviting Frank Amundsen and Trisha Moore on to tell you guys a little bit more about this entire event that we're hosting right now, and how we're sort of pivoting, and then to introduce Elliot as well.
Well, thanks, Scott, and thanks, Damian. I feel nervous now and scared, and I'm glad I'm at home right now where I can have panic attacks behind the camera and you can't see me. So thanks for all your suggestions, all your help. Appreciate you guys. Real quick, though, I want to talk about our social media trade show that we're starting tomorrow. For you that don't use social media too often, please take a chance, get a Facebook account. It's super easy. Get an Instagram. And then SAR is actually going to be posting up affiliate